as I recall, it was put to him that if it had happened, it was inevitable that
Yes.
he would have spoken to the other boy.
Now, I can read out the pages, but I don't wish to. In my respectful submission, the responses that you see there, but not only that you read there, but that you see there, and the manner in which they're delivered, at the end of those, one puts down one's pen and stares blankly at the screen and is moved. And at that point, in my respectful submission, any prima facie at least, any doubt that one might have had about the account, prima facie is removed.
Is there any significance at all for the purposes of this application in the fact that the same evidence was played before a different jury in a first trial and at least 2 members of that jury did not accept it beyond reasonable doubt?
No.
We simply ignore that.
Yes. So...
It's just that you make the point that this is so obviously compelling and so clearly reliable and truthful. I just wonder how that squares with the fact that another jury were not able to agree, and we don't know the numbers, nor should we, having seen and heard exactly the same evidence.
Well, I'm arguing about this case.
This case concerns the same evidence
Yes.
and the same matter, which is the credibility
Yes.
of this complainant.
And I'm arguing wherever in that, if I can term it this way, that shadowland between the legal question and Your Honour's being a second jury, I confess I don't know quite where I mean, Mr. Walker helped us considerably yesterday on that question. But wherever that is, whether it's certainly not the legal question you further. My entreaty, or my submission, I should say, more correctly to Your Honours, is that in the end, it's really Your Honour's view. I know at some stage the Constitutional Tribunal of Fact must come in and you must pay deference, and of course I rely upon that notion. But Your Honours have to make, to some degree, an individual, as Mr. Walker urges you to do, assessment.
Well, there's no doubt about that. I think it's common
yes,
ground, that,
yeah.
and we made that clear yesterday, we assess the evidence for ourselves. I think it's also common ground that the question for us is, was it reasonably open
Yes.
to the jury to conclude that he was credible,
Yeah.
telling the truth?
Well, if I can put it this way, Your Honours, if I can convince, or if Your Honours are convinced, I should say, that of his credibility and truth, then the next conclusion would seem to follow fairly easily.
Well, that comes back to my earlier question. It's really to get behind the assertion and the counter-assertion. You can see from the way he answers in cross-examination that he's making things up, or it's clearly fantasising, which he's come to believe on the one hand, or you say he's clearly not a liar. And I'm really looking for assistance regarding the tools that we bring to bear. I mean, you might say this is part of what judges are trained to do, but where there's such a diametrically different contention about the conclusion, it seems to me one would expect the submissions to be supported by propositions. Well, when you look at that,
well,
it's got a ring of falsity or a ring of truth about it, for example.
Well, I think, as we've said in our submissions, I can't fillet it out. I can simply say that it seems the cross-examination, to my mind, if I might put it this way, it's almost like a drama. It reaches its denouement at that point, and it builds
that section of the cross-examination.
Yes, and but and then the if I can put it this way, Your Honours have seen we had discussion yesterday about between, I think it was Your Honour the President and my friend, about the placement of the second incident in a rather perhaps objectively unlikely place, and what that might do to, in and of itself, to bear upon the question of lying or accreditation and so forth. Submissions were made about that.
And do you want to make a submission about that?
Well, can I say that before I get to that? Have you not seen the walk through that he makes when he enters the?
Just for clarity, I've seen everything that I was asked to see. So all of the defence, I call them defence witnesses, but witnesses called at the behest of the defence. So
you see him. Thank you. You see him in.
At least one of us has done all his homework.
You see him walk into the room, and we know what he says. It's eerily similar to the way it was. Of course, his evidence is that he'd never been in there before. His evidence was that he hadn't been in there since, and there was no contention. Well, ultimately, there was some discussion about this, I think, between Defence Counsel and the trial judge about whether there would be a contention made about some form of transplant or displacement from the walkthrough to trial, or to the evidence, I should say. But he identifies the alcove area. Generally, he says that's where we were. With the wine, and then he's asked, well, but where did the offending happen? And he steps back, and he, as Your Honours will have seen, or as Your Honour Justice Weinberg will have seen,
no, we have all looked at all.
Yeah, also, no, I'm terribly sorry, Your Honours. I didn't. You've all done your homework, excellent. But the places it in. Really, the somewhat the middle of the room, or sort of centre point, within view of one would have thought of the door, and you're thinking, I mean, it raises the question, I should say.
We've also had the benefit of being in the room.
Yes. If he was a liar, or a fantasist, it's so easy just to put it into the alcove area. Now, doesn't do it. So, a witness, I would submit respectfully, and it's a matter ultimately for Your Honours, and it was a matter for the jury, without guile, without in any way being shown to be a liar.
Mr. Boyce, can I ask you the same question I asked Mr. Walker?
Yeah.
The two themes were pursued in cross-examination and again in final address. There was, on the one hand, concoction, a calculated review of the committal transcript to spot gaps and fill them, or at least having spotted them, then filling them quite deliberately, falsely, and then that this is, as it were, an innocent fantasy. It's not purposeful. It's an involuntary act of imagination, which over time comes to be believed. Should we be asking ourselves those questions? I mean, by implication, you're submitting at least we have to ask ourselves, well, does this look or sound like lying?
Yes, absolutely. Absolutely.
And equally, I take it you say we ask ourselves, does this look or sound like fantasy?
Absolutely.
Are the indicia we would look for different? It
Yes.
just occurs to me they would be,
Well,
because it's such a different conception, involuntary self-delusion on the one hand and calculated falsehood on the other.
yes. And you see, not only do I submit that it was, if I can put it open to the jury, or at least open to Your Honours, to find the account compelling, but we had some argument about this yesterday with my friend, and I think it was pursued by Your Honour the President. In my submission, in rational terms, it was supported by those two forms of knowledge that we spoke of yesterday. The first knowledge, of course, was the knowledge that related to knowledge of the layout of the room.
So just to be clear, to what, this is the paragraph 48 point,
Yes, yes.
to what proposition is this directed?
This is in...
The knowledge that you assert, and of course you'll
Yeah.
need to deal with Mr
I will.
Walker's point that there was no basis for
Yeah,
your assumption, but to what, on my question about how we approach lying versus fantasising,
Well,
how
it supports the truth of the
I see.
account. Yeah.
it's one of the matters you say
Yes.
the jury could look at and we should
Yes.
in judging whether he was lying.
Yes.
Yes?
Or
fantasising,
yeah.
yes?
You see, the argument put below was that how otherwise could the complainant know about A, the concealed alcove area, B, the storage kitchenette, C, what my learned predecessor termed the wood panelled area. Your Honours may or may not remember the evidence. I think it was both of, I think Mr Portelli, Monsignor Portelli, who said at that time there were
It was vinyl rather than...
vinyl concertina doors that covered both what is now the sink area and the alcove area. There was a wood panelling finish upon that, at least in Monsignor Portelli's view, badly gave the image.
If you looked at it quickly, I think he said
Yeah.
you might have mistaken it for wood.
That's it.
There were
Yeah.
some witnesses who said, at least one witness who said it looked much the same. I
Yeah.
think it might have been Potter.
Yeah, well, I think Mr Potter spoke in terms of it being wood panelled, if my memory serves me correctly. So, now, the fourth matter that was relied upon by my learned predecessor below was that the alcove area was where the wine was kept. Now, what was Mr Potter's evidence about that, or at least on one version of it, was, I suppose,
Mr Boyce, I'm sorry.
I'm sorry.
having difficulty hearing you.
I'm terribly sorry, Your Honour. I'll just speak up. I'll just
If you would.
speak louder. Forget
If you
about
would.
that.
Throw caution to the winds.
Yes. We remember Mr Potter's evidence about the alcove, and he would always lock the wine away in that area, and at least insofar as he was concerned, there was I think a sacrarium there at the time. There was a few less shelves.
There was a fridge as well.
Well, he said originally there was no fridge, but then ultimately he said there was. But there was, let's assume there was a fridge with a wood. And now, my learned predecessor below says to the jury, well, how could he know about these things unless he was there? The consequence of that being, it would at least get the complainant into the room at or around the time of the offending. That's the consequence of it. Now...
That's not quite right, though, is it? It might get him into the room.
Yeah, that's all.
That's all. Not at the time.
Oh, well, when
in the relevant period.
At the relevant
when it
period.
was set out in
Yes.
that fashion.
Yes, yes. Sorry, that's what I...
Well, what you say is plainly correct. He would have to have been in the room at some point
Yes.
in order to be able to give that description before
Yes.
going to the police, giving the account and
Yeah.
taking them through the walkthrough.
Yeah.
That goes without saying.
Yeah. At or around.
Where does
time.
that lead?
Well, that gets him in the room, in the rough period. I mean, he was a chorister from 96 until some...
But what's the response to the cross-examination in which he concedes that he may have been taken into that room as part of the earlier tour through the cathedral?
The response is that not only is there no evidence that he was in the room at the time, because I mean, his evidence, and I don't want it to be circular, his evidence is of course that I wasn't. He says it earlier on. It's put to him, well, I should get it absolutely correct, I suppose. The question is at 357. I'll
which
continue.
Include...
I'll continue if I may.
Yes.
Prior to the incidents about which you have given evidence, you had seen the inside of the sacristy, had you not? Sorry, prior to the incidents that you alleged happened, the assaults you had seen inside the sacristy, I can't recall. You were taken, were you not, on a tour of the cathedral when you joined the choir? I would have, yes. And you were shown the sacristies? I have no recollection of that, no. Do you dispute it? No. So, looked at in the context...
You say there's no positive evidence that he had been in the room.
Precisely.
There's a lot of cross-examination of that kind. Do you dispute? And generally there's a response, no, I don't dispute it, but that, you say, does not constitute positive evidence of the matter that's put.
No, that's right. You see, it's often, one often finds in cross-examination in cases, footage to a witness, do you know if it was raining yesterday or something like of that nature? No, I don't recall. Well, do you dispute it? No, I don't dispute it. And that's where it ends. Normally there'll be some evidence about it having been raining, and there it is, and you've locked the witness in to that version. But here there was no evidence.
Does it amount to an acknowledgement by the witness that it is possible that he had been in that room beforehand when he says, I don't dispute it? Can it be read that way?
No. He has no recollection. The proposition is put. He doesn't dispute it. That's where it ends.
But if he were adamant that he had not been in the room, he would have said, I do dispute it, I was never in that room before. He didn't say that.
Well, he had already said he wasn't in the room, and a proposition is put, and you will recall at least by my learned predecessor, it was used as a make weight in support of the man's honesty. Now,
is it relevant to the question of whether he was a liar or a fantasist?
It's certainly. The other...
Just before we leave it,
yeah.
If someone if I put a proposition to someone that X occurred and their response is, I don't dispute, that's an implied acceptance, isn't it? I don't remember it, but I don't dispute it.
No,
I don't dispute...
I don't recall. Sorry, Your Honour, I don't mean to speak over
No, I'm
you,
just
sorry.
really
Sorry.
trying to test what you've
Yep.
said. If I don't dispute, well, I don't take issue with you. I can't confirm your assertion of fact, but I can't dispute it. I'm not able to say with confidence that it didn't happen, so I don't dispute it.
I mean, it's to the witness's credit if he answers truthfully in that way, but it does seem to me to amount to an acknowledgement that it is possible that what's being put to him is right.
Well,
I've always found that form of cross-examination somewhat unhelpful. It's sort of like the cross-examination which goes, is it possible that? And
Yeah.
unless one clarifies what one means by is it possible that, it's seldom helpful to the trier of fact. And when I've conducted trials, I've stopped that form of cross-examination and said, unless you're more specific about what you mean by possible, the question is of no assistance.
Looked at, you see, in order to break out of any suggestion that this is circular or self-supporting, it also needs to be looked at in the broader context of the evidence that was, I think, probably agreed and certainly unchallenged, that the sacristies were off limits to choristers. For example, Mr. Finnegan at 402.15, choristers knew they weren't allowed. They knew they weren't allowed to go into the actual rooms where archbishop or priests put vestments on. Mr. Finnegan, of course, being the choir.
What was the page reference?
402.15, line 15.
Permitted to use the sacristy corridors, but not to go into the rooms.
Yes.
I don't recall him having been cross-examined about that. In fact, that was during cross-examination. Was it, or in chief?
Excuse me.
In other words, it wasn't put to him...
So it's in chief, line 12. Were there any limits on where they could go within the sacristy corridors? It was protocol. They only went where they were allowed to go, so that would be the corridor. They know they weren't allowed to go into the actual rooms where the archbishop or the priests put their vestments on.
So on that view, that when... on that view, you led evidence to show that choir boys... well, the practice
Yeah.
was, the rule was that they weren't to go into the sacristies.
Precisely. And there's no positive evidence of any tour. I mean, that's what you would expect. You're setting up to adduce evidence about the tour, but there is no tour. There's no evidence of that.
What about the second point in paragraph 48?
Then,
About the unusual use of the priest's sacristy for the archbishop. Mr. Walker says, well, it wasn't established that he couldn't have known of that change of location.
well, he, as I recall his submission, it was speculative. I think he put it. It's speculative that to suggest that he didn't know of what I've termed the irregular change of location.
It's a
And
difficult case because, inter alia, you're dealing with detail. Detail is enormously important in this case, and you're dealing with details 22 years or so after
No.
the offence.
well, can I? Sorry, Your Honour.
No.
There's no question that the argument. Excuse me, Your Honour. The argument was made by my learned predecessor about this, and I've made, I think, reference to it in the footnote. Just happens to be that room, the very room, just happens, words to that effect in the closing, an argument properly characterised by the learned judge in his directions to the jury at 1576, line 20, he highlighted, that is Mr. Gibson, that it is no coincidence that the priest sacristy identified by the complainant is the very room that was used by Archbishop Pell to row as the Archbishop's sacristy was being renovated. So the argument is made that the jury can use the knowledge given by the complainant of this irregularity as evidence that would place the complainant in the priest's sacristy with the Archbishop at the relevant time. No coincidence. I mean, Mr. Learned Prosecutor wasn't arguing that the knowledge had come by some other means. His case was it came by the means of what was said to have happened.
Well, the case was it could only have known about that if he had been in there.
That's it.
On the occasion when he said he was
That's
there.
it. Otherwise, it's a coincidence, but it's not a coincidence.
And the argument against you is, well, that's just not made out.
Well,
in other words, you didn't exclude the possibility of him having been in there, either having been shown in or on some other escapade at some other time, or it having been known about that there'd been a shellacking of the drawers in the Archbishop's sacristy so that it was out of action.
okay. Can I take Your Honours to the evidence of Monsignor Portelli concerning this matter, because the picture becomes he sets the scene really about concerning this. The relevant passages are transcript 556, 5 to 9, and I'm sorry to have to do this to Your Honours, but it paints the picture that must be painted, because as I understood my friend's argument, it was to say this is speculative. You can't, and my answer to it is it's not speculative at all. It can be found, or rational inferences can be drawn from the evidence, namely, and that's why the argument was made and left to the jury.
Yes.
So at 5565-9 in chief, or in chief I should say, the Monsignor was asked why was he's being asked about the inauguration. Why was it?
Which page, please?
556. 5.
Which line?
Line
Please.
5. Or just, I'm just putting it in context. He's talking. The question is talking about the inauguration at the exhibition buildings.
This is in August of 1996. Yes.
So line 3, if I can go back. Was the occasion marked by a celebratory ceremony at the exhibition building in Carlton? It was. 5. Why was it
Probably
held?
skip through this, Mr. Boyce. This is the background. There was renovation
Sure.
going on.
Yeah.
We understand that.
So the cathedral was closed from Easter. So therefore the ceremony was held at the exhibition building. Next part, 557-26. There were, when the cathedral was closed, Sunday masses would be said in the hall of what was called the Knox Centre then. So when the cathedral was closed, Sunday masses in the Knox Centre hall, which is at the end of the Knox Centre up further east. 5797. I'll get through this, Your Honours, I'm sorry.
Did you say 5797?
579, line 7. Can I take you specifically to the latter
just say
half?
that again. What page, please?
Sorry, 579,
579. Yes.
line 7. Can I take you specifically to the latter half of 1996 and ask you whether the Archbishop's sacristy was available for the Archbishop to robe and derobe in, not before November the 23rd? Okay, so November the 23rd, the Feast of the Christ of King, the 6 p.m. Vigil Mass. And then, lastly, 579, 18 to 581, 1. Effectively, I won't take Your Honours through all that. What had happened was the workers, Mulholland had sent in a B team and it shellacked the furniture and the drawers were shut. So cathedral closed, between Easter and November the 23rd. We know from Mr. Connor's diary that there's no, that the Archbishop doesn't say any masses until the 15th, or certainly doesn't preside. And that unexpectedly, or contrary to what was intended, when he does first go to say the Archbishop's sacristy is out of operation, and Mr. Potter doesn't know about this. Mr. Connor has no recollection of it, and we know that generally speaking, the sacristies are off limits. It's not speculative at all to suggest, in the context of all the evidence in the case, that the only means by which the complainant could have come across that knowledge was because what he said actually occurred, and it wasn't by coincidence. I mean, on Sunday solemn masses, up until that time, we were in the Knox Centre, the other way, up the other end. No Archbishop in the vicinity from the 23rd through to the 15th.
There was other evidence to suggest that not throughout the entire period, but that the cathedral itself was being used occasionally for masses.
I think Lady Chapel or the other
yes, that's right.
smaller chapels. Yeah, but remember, the choirs only sing on the Sundays. On the 23rd of November, It wasn't the choir. It was the cathedral singers, the adult singing group. And so, quite contrary to what my friend submits, he says, well, the argument that was speculative. I mean, no one said the argument was speculative at trial. The argument was made by my learned predecessor. It was.
The simple way of dealing with it would have been to ask the complainant in clear and simple terms whether, prior to the day which he alleges the first incident occurred, he had ever been into that room. He could have said yes, he could have said no, or he could have said, I don't recall.
He did. He said he'd never been in that room before.
And then, when it was put to him in cross-examination that he doesn't exclude the possibility, in effect, that he had been there as part of a tour of the cathedral, he says, I don't dispute that. It's possible, in effect.
No, but that doesn't meet the second point, which is the knowledge of the objective fact that the Archbishop was using that sacristy on that day. So that was the argument made by my learned predecessor, and it's said by my friend that it's speculative. Quite to the contrary, there's a rational evidential basis upon which the argument could be made, and no doubt was made. That's why it was left to the jury. And if it's accepted, the argument cuts like a knife through butter, as it were, because it puts, the case is fought on opportunity, it puts the Archbishop with the complainant in the room. It would have to be alone because no one else saw anything. Now, that's the second argument that was made in support. There were two arguments made, and they're recorded by the judge. I haven't read His Honour's summation of the first one. The first one is the one we discussed earlier, which gets him into the room. But this argument made by my learned friend, I should say my learned predecessor, gets the complainant into the room at the right time with the Archbishop. Now, pausing there, if I may, if the jury were, or Your Honours were persuaded that of my first contentions, that is to say, the complainant's evidence was inherently believable, and if there is, as a witness of truth, and if there is support, as it were, to be gained in the material by reference to the arguments that were made at trial. No one said the arguments couldn't be made or that they were speculative or anything like that. That could support that. Then at that point in time, the position vis-a-vis the finder or the tribunal of fact and the complainant is, looking from, I guess, the Crown's perspective, pretty good. And the question becomes then, and this is how the jury were directed, the question becomes then whether any of the other evidence adduced in the trial necessarily or cut across or that acceptance. You see, the way in which the jury were directed was, you've got to be satisfied beyond reasonable doubt of the complainant's story. And then you look at all this other evidence and see whether that creates a reasonable doubt.
Although I think the defence would say you can't segregate them like that.
Well,
In other words, you can't do it as a two-stage credibility assessment because the combination of improbabilities is such that you would, at least in the process of assessing his credibility, have a doubt. In other words, you look at each statement he makes about what happened and where it happened, and you say, but not in the light of what
Sure.
we've heard.
okay.
There are plenty of cases, aren't there, where the court, the Intermediate Appellate Court or the High Court, has said the complainant seemed credible or was credible, appeared truthful and so forth, but nonetheless the verdict is unsafe because, and there are various reasons, objective improbability, evidence of other witnesses. Palmer, for example, where the court found a cogent evidence of an alibi, if you like. So that's the beginning of the process. We have to consider the evidence as a whole, every bit of it.
And this is where the, if I might, this is where the approach, if I'm with greatest respect, the approach adopted by our learned friends, he has a seductive appeal that again, with the greatest respect, it's submitted is prone to mislead. And can I make the submission about it this way? You see, and my learned friend will obviously do this far better than I can, but in terms of characterising his, but as I characterise his argument, he comes along and says there are these 13 issues, and we've got binders that separate them all out, and we've got tables that are different, and we can pour the evidence into each of these and look at it somehow as if it was a sort of hermetically sealed, each one test tube or something like that, and say, well, that just doesn't fly. That this was unchallenged, no section, and so forth. The argument was speculative and so forth, and then therefore, whether it be table A, table B, table C, or whatever it is, it can be crossed off, like as if we're doing a...
You're in effect asserting or arguing that Mr. Walker fell into the Hillier error of looking at pieces of evidence in isolation rather than the case as a whole.
Well, it's species of it.
He would accuse you of the exact same error, if I can put it that way.
A species of it. It's not. It's this. It's that the. It seems to me, with respect, that it's very unlikely that the jury would have looked at the case in such a way, notwithstanding the judge's eminently helpful roadmaps that were given to the jury.
If I can just indicate, it doesn't help me at all for you to invite us to speculate about what's likely about the jury's path of reasoning.
Can I?
You've got to deal with how we should.
Sure.
Think
My
about
submission to you is you look at, you see what the process that's been engaged in with respect, it's submitted, creates, as it were, a different trial. Your Honours will have witnesses who follow one after the other, and in so doing, the evidence that they might give about, let's say, opportunity on the steps, or whether the Archbishop was alone, might be the final picture that you have of that witness's evidence about those matters. You might come to that after having viewed the examination in chief, the cross-examination, and then the re-examination
Of the complainant.
of the witness
Of the witness.
himself. I think they were all male.
In the light of all of the evidence.
Precisely. And it's not, you see, and I'll come straight to it, if it was the case, for example, that Your Honours viewed, let's say, the evidence of Monsignor Portelli and came to the view that in chief he was on those issues relatively unsure of himself. That is to say, if you found parts of the transcript wherein the Monsignor said, well, I think the Archbishop might have been there on 2 Sundays of Advent.
Just before we come
Yeah.
to the details of what Mr Walker called the opportunity witnesses, can I just ask you to explain a bit more about really the sequence of evaluation?
Yeah.
I suppose it's one thing we do know is that the jury will have thought about the witnesses in the order in which they heard from them.
Yes, yes.
And one would expect that as a matter of ordinary human thought process, you would be constantly asking yourself, in the light of having heard, in this case, from the complainant, you bear that in mind, as juries are expected to do, and eventually have the transcript available as required, and at each point you
Yes.
ask yourself, well, now, just a minute, that doesn't accord with what the complainant said.
Yes.
That's how it plays out, isn't it?
Exactly. Yeah, I agree with Your Honour with respect. Exactly.
So that it's not quite as you said before, well, we look at the complainant and on your argument, yeah, clearly credible.
No.
Then is there anything, I mean, it is just a starting point.
No,
isn't
I
it?
agree. I agree. No, the point I'm making, and I don't think extremely well, is exactly. I'm attempting to make Your Honour's point.
I see. So you
So
would assume,
Yeah.
and in any event, it's how we will do it,
Yes.
have already been doing it.
Yes, no,
naturally,
of
because
course.
you're trying to get a sense of the whole of the evidence and
But
what does one piece tell you about another piece and so forth.
sure, but you might approach it by saying, I've got this prima facie view, let's say, about the complaint. Let's see what the evidence of Monsignor Portelli does, and then we'll look at that. Then we'll move on to the evidence of McGlone, the evidence of Mr Potter, and the evidence of, let's say, Mr Connor. We've basically got two tributaries here. We've got the tributary of an archbishop soon after Sunday solemn mass coming either from the steps after a period of short time, but having to be into an unlocked priest sacristy within a fairly short period of time. And we have the other tributary, of course, is we have two choristers who must break from the procession and come back and through the south transept into the same sacristy moments before. But let's have we look at the first tributary, if I can call it that, and we ask ourselves, well, when we read through or we look at let's say Monsignor Portelli's evidence in context, like from start to finish, and not cut up into what do we in the end? Does he qualify or detract from the complainant, or can we put him to one side? And it's not.
So your submission, if I've understood it, is that in undertaking that process ourselves, in progressively evaluating and re-evaluating the evidence as we read it and watch it, your proposition is that we should start, assuming chronologically we viewed the complainant first,
Yeah.
with a positive view of his
If
credibility.
if that's the view Your Honour.
No, I'm just
sorry,
talking about your submission.
Sorry, Your Honour.
And your submission is that though we would be asking ourselves the question, do I doubt this or that aspect of the complainant's account in the light of the later witness or witnesses, your submission is that we should not feel compelled to have a doubt
Precisely. You see,
by any of that evidence viewed cumulatively, as it must necessarily
Yes.
be.
Yes, and executive summary, if you like, of those witnesses is to, let's identify, like one of the main witnesses upon which the defence relied was Monsignor Portelli, because as Mr Walker correctly identifies, he gave evidence, in effect, of alibi. But when you go to...
I'm not sure myself that that is a helpful concept to use.
Well, no.
It's a metaphor, perhaps,
yeah.
but alibi really means evidence to show that at a particular time you were in another place, and the evidence didn't purport to be that. It was a question of the probabilities based on a newly adopted practice.
Sure. Mr Portelli, or Monsignor Portelli, in cross-examination, gives evidence that, unless I'm incorrect about this, that I was with the Archbishop on the 15th and the 22nd. I was on the steps with him for at least 10 minutes or so, or thereabouts, and I was with him all. So this couldn't have happened. I came back to
If it was reasonably possible that that evidence was true and accurate, where does that leave the first incident?
If it's reasonably possible, then I would have thought it would leave it in some difficulty. But the point is that when you go to Monsignor Portelli's evidence, what I contend is, and I won't take Your Honour through it in detail unless I absolutely have to.
Well, you might have to.
I think I will, yeah. Is that in chief, he doesn't say that. He says, in fact, it's very qualified. He might have been there. I'll take Your Honours to that. This is the executive summary.
We need to see the whole of his evidence,
sure.
not just what he said in chief.
Oh, no.
He said in cross-examination as well.
I can do that.
Yes.
I can do that now. But before, so there's one point just before I get there, and as a preliminary, if I may. And it's relevant to this exercise that I'm about to engage in. Much was said yesterday between my learned friend and the bench concerning the ideas of possibilities, and you'll remember the debate we had and how that affected the onus and standard and so forth. The nomenclature that was adopted in argument was essentially, defence says this is impossible, prosecution says this is possible. And you heard Mr Walker say yesterday, and he said, well, look, if there's evidence of an alibi, then nothing a complainant is going to say is going to change it. If that's a cast iron alibi, then it's impossible.
And as we said, if there was unchallengeable evidence that an accused person was in another country, then that's a cast iron alibi.
Yeah.
That's not what we're talking about.
No,
here.
that's precisely. You see, in this case, predominantly in terms of the evidence of practice, the defence says it's impossible because of this practice. The Crown says, well, no, it's possible, but that's not the end of the matter. Once it's possible, then we can look at the evidence of the complainant who says, well, this actually did happen, and the two things can kind of, there's an interplay between them.
But once you say and establish that something is possible, does that mean you then disregard the force of the evidence given by, for example, Monsignor Portelli?
No.
Or do you include it in your overall evaluation?
No, you include it, but you include it with the complainant.
With the qualification that it is accepted that it is possible,
Well,
whatever possible means.
True, but once you accept the complainant who can bear upon that question, then obviously if you accept the complainant, then it no
The
longer...
question is whether we accept the complainant.
Of course, but it's one form of reasoning. My point is that if you've got a cast iron alibi or something like that, a photo, whether it be what the complainant's not going to help you.
Because what the complainant says on that hypothesis cannot be true.
Quite. But if it's...
Two propositions of fact are inconsistent.
Yeah.
X was in Melbourne and X was in Auckland. They can't both be true.
Yep.
And we're not answering that question necessarily. We're asking the question, aren't we? Are we satisfied beyond reasonable doubt of the credibility and reliability of what the complainant says beyond reasonable doubt?
Yes, that's right. And because his evidence bears upon this argument about possibility or impossibility, but it doesn't affect the ultimate... I'll move to the evidence, but it doesn't affect the ultimate question. And indeed, in his honest directions to the jury, it didn't either, because this argument about possibilities gets strained through impeccable directions concerning the standard and onus. So it's all fixed up, as it were. So there's no danger about this. All I'm suggesting is that because what my friend said about what he might say about this possibilities in the written case in reply, is that it doesn't affect the onus in the way in which it was dealt with at trial, and that's how it was dealt with. But I'll come to the evidence of Mr. Sorry.
When you do that, can you also address us about the disadvantage of it being being a long time ago?
Sure.
Because I think that's also relevant when you're assessing the evidence, taking
Yep.
into account
Certainly.
that. Thank you.
So Monsignor Patelli's evidence, well, the relevant part of the evidence commences at, I think,
Somewhere in the 590s, I think.
580.
580s.
Thereabouts.
There's a concession by Portelli at page 591, lines 5 to 10, I think, that you would probably rely on, or seek to rely on.
But
About line 5.
can I take your honours back to 580?
Yes.
Which line, Mr. Boyce?
So 580 lines 23 to 28, we have him saying, well, I was there, I would help him put his vestments on. Then at 580, (29 to 31), we speak about other priests would have been present. But the important part is 581, it's really from 2 to 30, and I'll let your honours read it. The important parts are 15 and 16, and importantly at 25 to 30.
Why is 15 and 16 important?
He can't... ultimately he's going to say, of course, that he was with the Archbishop on the 15th and the 16th, or the first time. In chief, he can't recall whether there was process internally or externally. Now, if he... the proposition is, if he can recall, actually recall, being with the Archbishop on that day, then he would have to remember whether there was an external or internal procession, if he really recalls it. At 25 to 29, do you recall any specific mass said in the latter part of 1996? 26. Well, there would have been the Mass of the Vigil of Christ the King, which is the last Saturday of November. There would have been the 4 Sundays of Advent. I think the Archbishop might have been present at 2 of those, and then, of course, the Masses on Christmas Day. So the Archbishop, and then over the page, and the 4 Sundays of Advent are when? The first 4 Sundays of December, 2. And he was present, you say, you think for 2 of them. I think so. He would have been in Sydney for the Bishops' Conference for part of it. Then,
Is your point that he's unreliable as to his memory?
well, yes, the point is that when asked, unbidden, as it were, in chief, do you recall any specific Mass said in the latter part of 1996? His answer is, well, there would have been the Mass of the Vigil of the Christ the King, which is the last Saturday of November. There would have been the 4 Sundays of Advent. I think the Archbishop might have been present at 2 of those. I think so. He would have been in Sydney for the Bishops' Conference. Then at 20, he's asked about the practice concerning procession, practice concerning external procession. Not actual memory of Masses in the latter part of 96. Then at 5.8, I won't undertake your honours to this.
I'm sorry, I missed that page.
Sorry, 5882 to 591, I don't need to take your honours to it, but again, practice concerning the latter part of 96. But then at 590, line 3, we get to really the crucial point about what the whole section 38 application was about. That is to say, well, if there's evidence of a generalised practice that is unfavourable to your case, you can cross-examine to say, well, maybe it wasn't followed at times, or it's possible that it wasn't followed. And that's, you get that evidence from 592 to 591, 21. For example,
That's
20.
about as good as it gets, isn't it? It is possible that there may have been an occasion
Yep.
when Portelli did not accompany the Archbishop
Yep.
to the sacristy.
In accordance with what had been debated earlier in the Section 38 argument, this is it. This is in chief. Then at 592 we come to vestments.
591 seems to me to be important from line 5 onwards. Part of it's in your favour, part of it perhaps less so.
Yep. But that's the state of his. In chief, he might have been there for those two.
He concedes that it was possible that the Archbishop would have been left alone as far as he was concerned, at lines 5 to 10, and then he's asked about clarification of that, and he says if we had another function in the cathedral that afternoon,
Yep.
he would have gone back to the sanctuary
Yep.
by the back entrance and so forth and so forth. How
Yep.
long would you have been gone for? 2 minutes.
Yep.
Where does that leave you?
Well, it leaves
Is
me.
that a qualification of a kind that is relevant to the point that's being made by the defence?
It's him talking about a practice that he, in terms of specific memory, which is in the terms in which it's expressed. But the point, sorry, I hope I'm answering Your Honour's question, but the point is that when we come to the cross-examination, the memory becomes far more clear. And he's cross-examined into a position, in essence, of having an actual specific memory of these.
Do you say that that is a falsehood on his part?
Well,
That's the implication of your submission, that he's assisting the defence by purporting to have a memory which he doesn't have and cooperating with Mr Richter's cross-examination. Now, I just want to be clear about
Yes.
that. Are you saying that
Well,
that's untrue?
And this
His
was,
evidence is untrue.
and so much was recognised in my respectful submission was when we come to the re-examination by prosecuting counsel when he re-examined on it. The effect, because there are basically two aspects that again, in the cross-examination, I remember these 2 days. I remember I was with him, and not only that, but I remember these other events. Your Honours may remember that latter part of the cross-examination. I remember these other events building up to that. We were on the 10th of November and so forth, and other events. Then in re-examination, without objection, the learned prosecutor effectively says, all right, tell us about who you were with on this one. Oh, I can't, I haven't got the lists in front of me, and so forth. So the attack is made rather deftly upon his statement that he actually does have a specific recollection in cross-examination.
So he lied about that?
It wasn't suggested that he lied, that it clearly suggested that his memory was wrong. He couldn't do that. And there's at the end of the, I don't know if this would assist you. I mean, I can take you through it all, but that, if Your Honour's wish, but it might take some.
I think it's a reasonably important
Okay.
point.
Then. So, okay. So we're at the cross-examination, which the first part of that I want to draw to Your Honour's attention is 596, lines 9 to 13. Now, Monsignor, 23 November 96, does that accord with your recollection as the first time that the Cardinal said Mass at the restored cathedral? That, yes, that was the first Mass from the new sanctuary. So now we have recollection of this in cross-examination. 596.22. So the first time he would have said Sunday Mass, Sunday Solemn Mass would have been on the 15th of December. That would seem correct, yes. So we're not quite there, but we've got what seems. We have records of him saying Sunday Mass on 22nd December, but no other Sunday Masses in December of 1996. That would be correct. Well, there aren't any others. Does that accord with your recollection? Yes. Now he's Well,
people are sometimes prompted, aren't they, Mr Boyce?
Sometimes, yeah. But now, those were the period of Advent, the 15th and 22nd, yes. And you do have recollection of that first Advent on which you served him as Master of Ceremonies. I did, yes. (597.1) to 598.7, the highlighted parts. There are bugs in the system, we've dealt with that. As you went along. You were always with, at line 18, you were with him in the same area while he was saying Mass, always. Going into Mass and coming out of Mass, you accompanied him always. So we've gone from having he might have been there. I can only speak about practice, which may have followed or may not have, to in cross-examination, saying in the same area, saying always, going into Mass always, whether it was and so forth. You would wait, and then or interactions like this at line 30, page 597, the cross-examiner, you would wait with him, yes. Oh no, you did wait with him, I did.
Again, you're going to have to deal with 598 lines 1 through to 6.
Yes, so
He explains why he has a specific recollection
That's
of those 2 Sundays
That's it.
and reaffirms that he was with him on those 2 days throughout. Now, is he lying about that? Is his memory mistaken about that? Is he simply going along subconsciously wanting to assist the applicant? What's the Crown's position on all that?
I've got to take you through before. I've got to get to the re-examine in order to explain that. You see, the point is that he's agreeing with things in cross-examination that are at odds with his unbidden account when asked by the prosecutor about his memory in the latter half of 1996. Now, that's what it is. Now, at 628, we find over to 601.21, again the firming up of this memory, actual memory of which could amount to.
The page was 628. Did you say a line as well, Mr. Wallace?
I think I said 600, line 28.
Oh, sorry.
Over to 601, line 21. Okay, now memory coming or increasing from what it was in evidence in chief. Then to 607. To 24. Again, I did. Good reasons, yes. So, again. Then this interesting part of the cross-examination commences at 608, which is cross-examining by reference to Exhibit K, the agreed statement of facts, and in particular from the events that were recorded, I think, in Kairos. The witness doesn't need to have a look at it. This is at 25. We have a record of what it said, and he's taken through and he remembers the 3rd of November. This is on 608. That's right. I believe there was tea there somewhere. He remembers line 21, conviviality in terms of drinks, canapes and the like. Yes. That particular instance, that particular mass started at 9 a.m. Yes. The mass itself and so forth. 611, or I'm sorry, Your Honour, 608 over to 611. Memories of these things. He doesn't have the lists in his hand. It's been put to him, do you have recollections of these things? Yes, I do. He doesn't have them. He purports to have a memory of all these matters. and I don't think I need to take your honours to the actual 6:14:18 church traditions, 6:14:25. Do you recall what happened on the first two Sundays? Said solid mass. No, it would have been because those are events in the afternoon, the days we would and so forth. 6:14:31 and following, 6:15. And following. So by the end of at 6:19, 1 to 10, and certainly by 6:22, 13 to 25, we have actual recollection of events referable to the latter part of 1996. Now, then we come to the re-examination, and 625, line 28, where in effect the Monsignor is tested about his actual memories or specific memories that he was purporting to have in cross-examination, which he didn't show in evidence in chief. 28. All right, now Monsignor, you've given evidence of various, this is 625 at line 28. Monsignor, you've given evidence of various memories you have of various masses said by the Archbishop in 1996, is that right? Yes. And you've been quite specific to your memory of what happened, where it happened and when it happened, is that right? Yes. So starting, say, with 3 November 1996, which mass was that Archbishop Pell said? That was the racing mass at St Francis. And you have an independent recollection of that mass, do you? Yes. And how you got there? Yes. You remember how you got there? Yes. Goes on. Where did you go once you finished, that is, once you left? Once we left that occasion, St Francis Church in Lonsdale Street, if I recall, you mentioned, Mr Richter mentioned, another mass that evening. I mean, directly or left St Francis Church in Lonsdale Street, we probably returned to the cathedral. And would have been there before 11 o'clock? No. When you say probably, you would have returned to the cathedral. Do you have a recollection? Or we're back to practice? Well, that would be the practice. We wouldn't appear in parish event 3 hours before it was to begin. So we would only appear, the normal custom with parish events was to appear about 20 minutes before it was to begin. All right, 627, line 2. And you say you probably returned to St Patrick's Cathedral after the race and confraternity mass, is that right? Yes, and we probably had lunch, yes. But before lunch, is it the case that there was an 11 o'clock Sunday solemn mass at St Patrick's Cathedral on 3 November 1996? Not in the cathedral, it was in the hall. And you're referring to the Knox Hall. Knox Hall, yes. And being a much smaller area, is at the end of the Knox Hall, is that right? The Knox Centre, well, it could accommodate 400 people from memory. What is your recollection as to who said mass at 11 o'clock on 3 November 1996 in the Knox Hall? That would have been either the Dean or one of the priests appointed to the cathedral, but not Archbishop Pell. You have a memory of that, yes. But your memory isn't to the extent of exactly who said mass. Well, if I wasn't there, I wouldn't know. And importantly here, in terms of 10 November 96, which you'd been asked about some pages earlier, where was it that mass was said by Archbishop Pell on 10 November? You'd have to remind me.
His point is that he remembers the two masses that were said on the 15th and the 22nd of December for a particular reason.
Yep.
What does it matter if he's vague, assuming he's vague, about events that occurred in November?
The point is that he was unable to give specific memorable evidence about the 15th and the 22nd in chief. Unable to. The best he could do was speak about practice. The prosecutor is in effect in re-examination testing the memory, not by reference simply to the 15th and the 22nd, but by reference to the purported memory of all these other events. When he ultimately
sounds as though you're putting a submission that involves being prepared to strike but not wound. You're either going to say that he is gilding the lily or making up his evidence to strengthen the case for the Archbishop, or you're not. I don't see how this is really a memory point at all.
Well, the point in the end, the prosecutor wasn't allowed to submit, was not permitted to submit lying.
Well, he disavowed any
Yep.
intention to do so. He could have sought and he
Sure.
wished to do so under Section 38 and the Section 38 ruling. He could have said, I'm calling these witnesses, I do not accept everything they say,
Yep.
and I want leave to cross-examine as to credit because it will be my submission that they're telling lies. Or he could have sought a variation of the Section 38. I'm not critical of the prosecutor, I should say. I think the prosecutor did a fantastic job, if I may put it, under very difficult circumstances for the Crown as well as for the defence. This is a very difficult trial.
The point in the final analysis is, Your Honour, is that you'll see the answers at the end. He can't answer the questions that he's purported to have the memory of without the lists in front of him. And this is the point we make in our written
But he
case.
says he remembers the 15th and the 22nd, and he gives an explanation as to why they stand out in his mind.
The point though is, in the end, the jury were directed that they could accept or reject any evidence that they chose. Now, we know that this jury, and I know ultimately, I hope it's not unhelpful for Your Honour, but you know what this jury did as soon as they went out? They asked for the recorded evidence of the complainant and the recorded evidence of Monsignor Portelli. Because it was those two pieces of evidence that were going to... That's where the conflict was. They're directed by the judge that they can accept or reject any evidence. The question in the final analysis is, was there a, leaving aside whether how far the Crown went with its Section 38 or otherwise, was there a rational basis for the jury to reject Monsignor Portelli in the face of the complainant's evidence when he said, that is, Monsignor Portelli said, I was with the complainant I was with the Archbishop at all times.
Is your submission that the evidence of Monsignor Portelli could be viewed as being unreliable? That whilst he may have had a reason for recalling the occasions,
Yeah.
the detail of where he was and when he was with the Cardinal at that stage.
Yeah. When you look at Monsignor Portelli, my point is this, is when you at the very end I should say that there's an intriguing answer given towards the end, and I'll see if I can find the transcript reference to it, but it's I'm sorry when it's put to him, how come it's you can't remember these things, but you could now in re-examination, but you could remember them before, and it's
Where is that?
I'm sorry. Yeah, no. I'm sorry, Your Honours, I'll just turn it up. (627) lines 23 to 24.
That's about the 10th of November.
Yeah, at 27 to 28, so 10th of November, because he's given evidence about the 10th of November just a number of pages earlier. 21. On terms of the 10th of November 1906, you've given evidence as to what occurred on that occasion. Where was it that Mass was said by Archbishop Pell on 10th of November? You'd have to remind me. And how many occasions what? On the 10th of November 96, from memory I think there were two. Do you remember where they were? I'm sorry, I wasn't trying to remember when I was told. It's difficult to know what he meant by that, but he may mean I wasn't actually trying to remember in cross-examination when I was told, without the benefit of the lists in front of me, what was going on, what actually was happening. These propositions have been put to me. Yes, thank you. If I was to ask you about the 17th of November, would your answer be the same? Yes, you would. I'm sorry, I don't have the lists in front of me. And again, I'm sorry I don't have the lists in front of me at 628, lines 13 to 14. This all went through without objection. My simple point is that when you look at this trial and you see what the jury asked for in terms of recorded evidence in order to resolve the dispute. And when you know that the defence couldn't place much emphasis on, with respect, on Mr Potter's evidence. They didn't try to. If Mr Potter could, they didn't cross-examine him in quite the same way. The eggs were placed in the Monsignor Portelli basket predominantly.
On this issue?
On this issue, yes.
And
And-
the cross-examination goes on about the 15th and the 22nd
Yes, Your Honour.
December. Or re-examination.
What page? Sorry.
It's just a few lines. It's on 628 lines 1 through to 17, and then it turns to the 23rd of February.
Yeah, that's right.
So the same list question,
Yep.
list answer.
Yep, that's right. So by reference to the 22nd. Thanks, Your Honour.
In the end, I suppose, consistently with what both sides are submitting, the question for us is what we make of this evidence as
Yeah.
with the evidence of each other witness.
Of course, no, but...
And
sorry, I'm terribly
that's
sorry.
not meant to be a statement for or against you. In other words, you point to what you say are changes in the account. Mr Walker relies on answers in cross-examination. We have to weigh up the effect of the evidence, the lapse of time and those sorts of things. The matter of uncertainty, which I raised yesterday, seems to me at least to be a feature inevitably of evidence about events decades earlier.
Mm.
And that's a setting issue for the jury, I would have thought, and it may assist the defence as much as it assists the prosecution.
Well, the point I was seeking to make, though, Your Honour, in my preliminary remarks, is that if you were to go to my friend's binders and look at these issues as hermetically sealed questions, you wouldn't get that. You don't get. I'm not. Obviously, Your Honours would read the evidence in chronology. But
Just to be clear, I didn't take it to be hermetically sealed containers. It was broken down helpfully.
Obviously, yes.
The
No.
whole thrust of the argument is its combined force. And
Exactly. No.
I'd like to ask you about that after the break.
I accept that. The point is that if you not hermetically sealed, I've overstated it, but if you look at them, if you read the evidence of Monsignor Portelli from start to finish, you know that the jury must have rejected it insofar as it created a doubt concerning the complainant. Then you can, when you've gone from start to finish through the chronology of events and the lack of memory, the sort of memory that arises in cross-examination and then back to practice and lack of memory again in re-examination, there is a rational explanation for why the jury would have or must have rejected Monsignor Portelli on those crucial points, the points about which he said he could effectively, I'm sorry, I use the term advisedly, but alibi the Archbishop. And that's important with respect, Your Honours.
We'll take a break now for 15 minutes.
Cool.
Thank you. The applicant can be taken from the court. Thank you. Adjourn.